up, ladies and gentlemen? We are back. We are live. It is the Freight Coach Podcast, the top podcast in transportation, coming to you guys every single weekday, 8:30 a.m. Pacific, 10:30 Central, to break down some industry headlines. But most importantly, you guys provide some actual insight into what you can do with all of this information. If this is your first time tuning in, welcome. This is the real side of freight, ladies and gentlemen. And I do say that before every single show. And what I mean by that is I only speak with transportation professionals, because at the end of the day, I want to talk to the right individuals who have done what you're looking to do or who are currently doing what you're trying to achieve, so you can take that information, apply it, utilize it, and see a meaningful difference in your business and your life. Happy Wednesday, everybody. I got a very special guest for you guys here today. It's been a minute since he's been on the show, and we're going to talk about what this actually means from an insurance standpoint in regards to the SCOTUS ruling. As you guys all know, a bunch of stuff came down. There's a bunch of changes out there, and I've heard from multiple people about their insurance policy. What is this going to do? What does this all look like? But most importantly, you guys, as I was like, what can you do to protect your business out there? So I have my resident insurance expert coming back on the show, my man Cam with Valley Trucking Insurance. Cam, thank you so much for taking the time to jump on here today.
Hey, what up, buddy? How we doing?
Oh, dude, we're doing good. It's a lot has kind of come down the pipe here these last couple of weeks. And just like with everything, everybody's got an opinion on it, and very few people are qualified to actually speak about what it means and what it could mean to their business. So, but dude, what's been good with you, man? How's everything been going?
It's been going, dude. It's been a busy season, it feels like. And then at like a high level, you and I have talked about obviously trying to operate a business, raise a family. Congratulations, by the way. And then just, everything that goes with that. And it's been bananas. So we're actually, next time you see me, or next time I'm on the show, we're going to be going through a rebrand. So we actually went through the process of getting an updated logo and brand and stuff for actually like kind of bigger picture stuff down the road. And so I'm excited, trademark and a bunch of that kind of stuff that's coming down the pike. So we got a lot of things in the works, a lot of technology and vendor updates and partnership updates. And it's exciting, man. It's been awesome.
Hell yeah, dude. That's the thing, right? Like it's such a good reminder that like no matter what goes on out there, like the business has to keep moving, and I think like there's so many times that we kind of get stopped in our tracks, at least as, like in entrepreneurship, right? Like you and I have talked multiple times about this, and, on air and off air. Like for me, man, the hardest thing of business, it's not the work itself, it's the systems development, right? Like, cause there's always going to be something that comes in and could affect your business in one way or another, whether it's the market, whether it's, Supreme Court ruling or some law that gets passed out there. But for me, it's like, dude, how do you develop that system to make it work? And, for me, it's like, you don't actually know if it's working for like 90 to 120 days sometimes. And then by the time you get there, you're like, shit, I got to redo it all over again.
I don't know if it's working until you find out it's not working. Honestly, like that's my experience. And then it's like insurance. It's like, well, it never matters until it actually matters, and then a lot of this stuff comes back to the process and procedures. It's so funny. I was thinking about this when this ruling came down. I actually had tagged you on a video we did and some stuff on social media, but it's the same. It still falls in line with a lot of what you and I have talked about from the very beginning, where it's process, procedures, repeatable procedures, documented vetting processes. Do you follow those processes? And now it's taken it maybe just to the front a little bit more, and it's ripped that defense veil away from the brokers. So, now the brokers that have no insurance, that's wild. Like if you're going to operate with that as a strategy. But then two, those that don't have documented process and procedures and vetting process and like follow it, right? If they do have it and don't follow it, that's probably worse, because now the attorneys are going to just rip that apart in court. And to me, it looks, just from a quick overview, it just opens up another bucket for the attorneys to go after for insurance money, right? Or if you're a big brokerage, obviously, and you have asset money and you're doing well, you have money available to get drug into this as well. Now it's not just solely falling on the motor carrier. So it's pretty wild, man. I'm excited to dive into this conversation with you.
No, for sure. So let's talk about that, right? Because it's not required by law for freight brokers to carry insurance, right? Like now I will say this, any shipper of like actual substance is going to require you to have insurance, right? Like some form of coverage to get access to their freight. Do you think now, again, I won't go as far as saying it's going to be required by law for brokers to carry insurance. Do you think it will now be an absolute requirement from shippers that of any size, if we're looking at it from a risk mitigation standpoint, because again, shit rolls downhill, that like, hey, if you're going to move our freight, you have to have active cargo, contingent, all of that stuff. And can you explain the difference? Because I know some brokers go in and they purchase like the bare bones basic, like, is it contingent cargo? Is that going to change to where you need a full-fledged cargo policy now, do you think?
I actually think this, the cargo is the one thing, right? Like that's pretty much limited to the scope of the value and what you're hauling. So that won't change much, right? Contingent cargo. And then obviously, are you utilizing highway or some of these tools for vetting process and that kind of stuff? You have internal vetting process and procedures to ensure that they actually have insurance, active insurance, the motor carrier being also, is the coverage form good, right? And do they have adequate insurance? There's a bunch of things that trigger on the cargo piece. I would shelf that for just a moment because I think a lot of this actually is going to come from the way of liability, meaning if there's a massive accident, if there's loss of life, or we've all seen like the headline stuff where multiple four-wheelers are involved in an accident. That's where I think it's going to shift to. So I do think it's a liability thing, but I also think it's going to boil down to the vetting and the process and like how well your carrier selection process is, right? So when you pick a motor carrier, really right now more than ever, it's going to be, can you defend that decision in court? And did you have a documented written reason why I went with this carrier, not just, hey, they were available, they were the cheapest, even though their safety scores are terrible and their out of service is bad, they got multiple accidents, whatever the case may be, because that's where the big money is going to get brought into. So contingent auto liability is going to be huge. E&O is going to be huge. The GL forms are going to be huge. And then excess and umbrella coverage are going to be coming into play a lot more. And a lot of that is really in court, whether it goes to trial or is settled before trial. But there's a lot more I feel like the attorneys are going to have to dive into. And a lot of it, I think, will be around internal communications, the emails, notes in your systems, your vetting process, all kinds of stuff that come, ahead of time of you actually booking the load with that motor carrier. So, and none of it all matters now, but it won't come out until there's a major trigger event, being probably an accident is most likely what's going to happen.
So I can't speak for every single operation out there. I can only speak for my own, right? Like we have a very strict like setup process to even get access to be able to move our freight, right?
Yeah.
And well, at least what I think, right? I'm sure any lawyer out there could probably pick apart anything. I'm not ignorant to the fact that some lawyer could probably try and pick apart our process or any brokerage's process that is out there. But ultimately, it's like if we use that, right? Like even if they have bad safety scores and stuff like that, like they can't even get access to our system. But what, and I don't know if you can even answer this, Cam, if we're out here, everything checks out on paper, carrier vetting, FMCS, like safety scores, everything checks out on paper. But it turns out that the carrier hired a driver that was illegal, that obtained a fraudulent CDL. How does it look then, right? Because like I'm not saying that that's going to be a common thing out there, but if we're looking at a checks and balance system as a broker, and I'm using my vetting software, I'm using the public available information that is out there, everything checks out on paper. Well, it turns out that one of their drivers caused an accident, unfortunate situation, and then it turns out that driver was here illegally and had a fraudulent CDL, because that has been coming up here a lot lately. How am I protected as a broker in that regard?
And You're right. Like it's tough. Like disclaimer, like I'm not obviously like a legal expert or even I know you throw the term special guest and like expert, resident expert and stuff. Like obviously I've been doing this for what almost 20 years now, but I'm by no means like the expert in the category, but we do spend a lot of time obviously being involved in what's happening and paying attention. I think a lot of that'll fall back to the motor carrier, right? Like they're the ones that are going to be in the spotlight in that scenario. Obviously, in the actual event of the claim and, when you go to court and that kind of stuff, to your point, if you did follow everything, cross your T's, dot your I's, you've documented everything, they've passed the system flags, so to speak, so they are able to book because everything meets it on paper. You've worked with them in the past, all that kind of stuff. You've done what you can do, right? You can't protect everything and you can't predict everything either, and you don't run their company for them. So I think the more that you just have documented and it's just followed time in and time again where it's like, hey, I've done everything that we could possibly do. So where does the negligence fall back onto us, right? I think you have a very good spot to defend from, and that's what I would focus on, right?
Do you think some of these, and I don't even know if you can answer this because I don't know the answer to it at all, but it's like now I think there's going to be even more of a reliance on carrier vetting software. I truly do.
100%.
Are they somehow going to be exposed to additional risk now with all of this stuff? Because like I would only assume, and again, I'm not accusing anybody of anything, but I would only assume that most brokerages' defense is going to be like, I used this software. This software said it was good. We followed all of our process. That software is bad. We would have never hired that carrier if that software was doing its job.
Potentially. I mean, you got to go back. There's a couple things at play there. So when you utilize a software, you can list whoever, there's a bunch of them. You're signing a contract with them, right? Like there's in the contract, there's going to be legal insurance requirements. There's going to be just all the different specifications in there. Most likely there's something in there where they're trying to say, hey, you can't hold us liable due to the outcome of that. Whether it holds up in court, depending on the circumstances, not sure. But more importantly, too, your contract, and this might even help maybe address that prior question, the brokerage and the motor carrier agreement that you guys have needs to be super strong, right? Like make sure it's reviewed and written by an actual attorney, freight attorney that is savvy in your realm, state, all the different jurisdiction stuff that you deal with, because that's where the basically attorneys are going to go first. Is what does the contract say? Not only does that contract say, did Chris Jolly follow what he said he was going to do in the contract? Meaning, hey, I vetted them, we ran them through this, they meet these thresholds for safety and out of service, all the stuff that you got in there. I verified their insurance, it's active. I verified the coverage amount was adequate. All the different things that come into that. If you failed to do any of that kind of stuff, you make it easy for an attorney to attack you. But if you did everything that you're supposed to do, and then also have an attorney review that contract of the vetting software that you're going to be using, just understand what is there and the exposure that's there, so that you have a better, at least knowledge going into it. I would say potentially it would make them more liable depending on what that contract, depending on the claims, depending on what that software is saying that they'll do. And if their system failed, then yes, I would assume that, that something would get drug into that. But, who knows? It'll be interesting to see any cases that come from that.
This is going to be a very general question, and I know that it's very much a case-by-case basis. Does this now make it borderline impossible for certain organizations to get insurance moving forward if they have any claim issues in the past, right? Any accidents, like negligent hiring stuff, whatever. Like I'm talking specifically as a broker. I have one thing that happened 2 years ago where we hired a carrier, load was stolen, they hit somebody, caused an accident, a lot of damages. Does that change my ability to purchase insurance moving forward?
I don't think any more than it did before, but to Because remember, insurance is going to act on actuary and then the data that's available and past history coming from loss runs and your selection process system. Because what they'll review is they're going to pull in financials, they're going to look at your broker carrier agreement, they're going to pull in a list of all the DOTs that you're actively using. They're going to run those into their own independent verification system to say, hey, these are good, these are bad. If you got bad actors in there, you got people that don't meet those minimum qualifications, some insurance companies won't actually do business with you, or other ones will make you sign a deal saying, hey, you're choosing to use this. However, there could be implications come a claim, and that kind of stuff. So you just would probably end up paying a little bit more. I do expect potentially like a tightening up of the underwriting process, meaning like, hey, there's more in-depth questions. Like they're going to dive a lot more into your process of selection for motor carrier selection. What's your vetting look like? What does that look like? And then can you show us the like system, right? Hey, write out what that system looks like, show us how it's accomplished, and maybe even give us some examples. Also, I would expect too, as this kind of progresses and develops, potentially like additional exclusions that come in to the insurance policies. It might narrow some of the scope of what it would extend and actually cover, or there'll be exclusions that if you failed to do XYZ, that you wouldn't be covered in that circumstance if you just were negligent on that carrier process selection. So I don't think it changes a ton. You'll still be able to get insurance. It's just that makes it harder for the smaller or the newer brokers, I think, that are already kind of feeling the pressures of the market, getting out there and hustling, don't quite have a book of business built, maybe don't have a great cash flow handy. They look at that 10, 15, 20, 100, however much thousands of dollars they're paying for insurance. That's a big piece of that P&L, right? Or it can be potentially, but it's really part of that defense strategy as well, along with, everything else that you and I have talked about. So
could all of this lead to higher insurance rates, or will this all lead to higher insurance rates? Because that's another big talking point
probably
that I see out
potentially.
there.
I mean, that's tough to say, right? Like the market will react. This was similar in my mind to like the cyber, right? Cyber insurance was a big deal, which actually that should be a big deal for freight brokers, meaning because you guys operate online and deal with a bunch of stuff. But social engineering claims, those fraud claims. In fact, I'm dealing with one right now with a motor carrier that was hijacked and somebody did a bunch of stuff, booked loads on their account. But anyways, yes, and that created a kind of ripple effect of you had a lot of insurance companies doing it and okay with it to, hey, now there's only a select few that will do it. And the application used to be 1 page. Now that application's like 12 pages. And now they need a bunch of things to just verify that you're doing what you're supposed to do to minimize and mitigate risk as much as possible, right? Insurance will end up being there, but if you failed to do what you were supposed to do, then it potentially won't have coverage apply, right? So those are the things that really kind of come into play. And it's tough because you're busy, right? So you might be thinking you're doing everything right, or you might even think, hey, my employees are doing all these checklists and all the steps and stuff like that. But unless you have a way to kind of audit and you have a really good system with whether it's automation or, I mean, AI is wild. I wouldn't rely heavily on like making it do your job, but there is some benefits to implementing some of that into your day-to-day operation, to just kind of expand what you can do from a time perspective. And so I think potentially, yeah, it'll lead to some rate increases and stuff. But probably more so on the underwriting, it'll just kind of tighten up is what my assumption would be on that, prediction will be on that. But we'll see. Now more than ever, it's going to be important that people start reviewing those contracts, because the insurance policy is literally just a contract. Like people tend to forget that. They think it's just a commodity, but it's actually part of your legal defense system. So
I am curious to hear your thoughts on this, because I look at a lot of, because like my big takeaway from a lot of this is, and I think what's very important to state here is the state you operate in, or the state of an incident, is going to be very key here moving forward, right? Like that was kind of like the main, and I think this was missed by a lot of people. That was kind of the main decision from the Supreme Court is like, hey, this is a state issue. And now that followed up with in unison, a Home Depot case, and I just broke this down on the show yesterday, Home Depot and Warner, where Home Depot was proven innocent in this, where a Warner driver hit and killed somebody, to the best of my knowledge. So, and like Home Depot like removed themselves from it. Do you see that as a precedent now where that will be like from a customer, like a customer shipper to either a carrier or a broker, where now there's going to be some clause where they're removing all liability from themselves? Because I look at this strictly as a risk mitigation ruling more than anything. Who is going to bear the most risk in these transactions moving forward? And people are going to try and, shit rolls downhill, man. People are going to try and throw, every shipper and manufacturer in North America is going to be like, how do we remove all risk from our freight now moving forward? Is there going to be an insurance policy as a broker where I'm going to be able to purchase that potential coverage? Or is this now going to be a thing where you are going to be going to all of your clients, your brokers and carriers that you insure, and you're going to be like, you guys can't haul freight for them anymore. You guys have way too much risk. There's nothing out here that protects you guys.
Yeah, that's a good question. And I think the venues for the different states and jurisdictions and stuff, you've got the bad acting venues. And when I say bad, it's really just not favorable to the trucking industry, right? More towards the consumers or the victims, depending on the circumstance. And then you've got more favorable ones. I know that there's a lot of work being done from ATA and the state associations. I know that our state associations working diligently on trying to fix and correct some of those things in the environment that we've been operating in, especially with nuclear verdicts and all that kind of stuff that we all see. And my guess is in those cases, especially the 20, 30, $40 million judgment cases, the broker and the shipper and everybody that was involved that touched that got drug into that case anyway, right? And it could potentially be, or people could have been drug into it before, but now where there was probably a defense strategy and there was some safety in place from just law, that veil got slid over now to where it's almost going to be expected that the broker's brought in and they're going to go into discovery and they're going to get drug into it regardless of who that shipper was. And I don't think, like I said, I think from a broker standpoint, it's still down to what you do and what your process is and how buttoned up you are. And as long as you are operating at the highest level that you can possibly operate at, like you can be sued for anything, as you mentioned earlier in the show, but like you become a lot more defendable. And so all of a sudden it's like, hey, we're out here, we're doing it right. We're operating with the public in mind. We're doing, carrier selection. We're vetting as much as possible. Yes, these routes run through Nevada or Louisiana or Texas or wherever, which tend to be a little bit more harsh jurisdictions to get into claims at. But you can only do so much, right? Like you still need to operate. I wouldn't let this scare you. I actually think it is an opportunity to become better. It's an opportunity to just kind of button up your process and procedures. I think for motor carriers, it actually becomes an advantage. Those that do place a huge emphasis on safety and out of service and, preventative vehicle maintenance and all that kind of stuff, like they now become a lot more attractive, right? Versus a motor carrier that, their scores are just off the charts and they just have a pattern and a history of bad operating and crash history and that kind of stuff. I mean, I feel like it will create like an adverse selection type environment for brokers to actually start looking at that stuff. And you already mentioned that a lot of these vetting tools are starting to do that, right? If they don't connect their ELD, if they don't have a certain safety score and operating history and all this kind of stuff that everybody can see now with technology and the data that's available, those companies are going to slowly just kind of get pushed out to the side. And there's still going to be need. There's probably still a need for them. Maybe not a need, but they're still going to get picked by certain people that don't care because some companies just aren't going to care. They're just going to operate as they always have and maybe get lucky, maybe not. I don't know.
Let me ask you this. So there's a lot of reports out there and they seem like they have been substantiated that 90 to 94% of trucks on the road do not have a safety rating at all. How is
Mhm.
it possible for that to be a thing and buy insurance? Like how could I go to you and buy insurance for my fleet, Cam, if I have no safety rating on the FMCSA?
So yeah, so the insurance is gonna look at a multitude of things. Obviously, one of the tools that are utilized is gonna be the cab, right? What's available from FMCSA for the public facing data? What does your operating history look like? And you're right, there's some that just don't have enough inspections to have a safety score, right? But they still will review violations. So violations and out of service and the other things will still show up. The other piece of that is like, as you know, you buy insurance for your vehicle, they're going to pull your motor vehicle report. There's what's called like a clue on the personal lines world, but loss runs in the commercial world, where they're going to say, hey, we need to review your history from an insurance standpoint. So have you had any claims? Have you had any accidents? Do you have any tickets? How old are you? What type of equipment do you have? Give us a good summary of what you actually do, where you haul. So they'll pull IFTAs, right? They're going to pull in like where their actual exposure comes in at, and just anything that's available to the insurance company that they can get from the either motor carrier or from a public database or a database that they have access to. They're going to bring that all in. So that doesn't necessarily affect us getting insurance now. In fact, like you had mentioned, there's a lot of folks or new ventures, right? We deal with a lot of startup companies or newer companies as well. They're not going to have a lot of history, but that's not like a negative to them. It does maybe limit what insurance companies will work with them, because we've all heard this within the first 2 years, like not all the insurance companies will work with you, right? They want to see some established history of 2+ years, 3 years, 5 years, and beyond. And then all of a sudden, a little bit more opportunity opens up and options open up for insurance company quotes and that kind of stuff. So, it's just what is available, because that's not the sole
Yeah.
focus of like insurance, is just looking at what the safety score is. So,
How are you going to work with your client? Because like I view this, again, and I've said this in, like I always say, I keep all my original recordings so nobody can actually doctor what I try and say. Um, Again, if we're looking at this from a risk standpoint, risk mitigation, if you have a direct shipper, and again, I want you like answer this from the standpoint of if one of your clients has a direct shipper and they don't have a safety score, and that is now a requirement to haul their freight, right? Because I don't know what every single organization is going to do from a legal perspective now to be like, hey, if you're going to haul our freight, you have to have these things. And if you have no documented safety record out there at all in the FMCSA database, what could a carrier do to prove that they are safe so they can continue to work with some of these shippers? Because I think this could inadvertently affect the smaller carriers at a level that I don't know if a lot of people are maybe even realizing. Because if we're looking at a lot of these things, and documented safety scores was one of the big talking points out there. And if we're looking at the data, 90 to 94% don't have that. I could see how a shipper might not give them freight anymore moving forward. How could a carrier prove that they're safe in that regard to continue to get that direct business?
yeah, that'll be interesting. I mean, and I wonder if the shippers would narrow their scope that much and not understand what the marketplace is, right? And I think that, what you do with the education and bringing on the different experts and their different topics and that kind of stuff, just trying to get it out there of like, here's how the real world works, that they would actually listen to that and be like, hey, there's more to it than just this safety score. And if you look too, because I think their history and like when the established authority came about, like what else can these motor carriers do to show them? Now, if they're a brand new company, and I think, within 3 months or 6 months of getting a new DOT number, a lot of brokers can't or won't work with those motor carriers, right? But if they've been around for 3 years, 5 years, and they still don't have a safety score, which is common, then does that change that? You know what I mean? Like it would be wild, I would feel like, if a shipper is like, no, I don't care, you've been around for 10 years, perfect record, but you don't have a safety score, I can't use you. Like, in my mind, that's wild, if that's how that goes.
For sure. I think that it might not be there yet, but like I've been saying literally since the very first statement that I've made on this, I'm
Hmm.
paying more attention to the next case more than that ruling.
Yeah.
Because if something happens where a manufacturer is going direct to a carrier and then heaven forbid that carrier's in an accident and there's a fatality, and then it's proven they were working with a carrier that had no documented safety record out there, what does that lawsuit look like? I think that that's going to be on the radar for a lot of people at that point. Again, I hope it never happens, but I'm also too old to realize that people are going to pass away in fatalities in very horrific situations. And I just like that. That's the thing that I see, Cam, as like a major exposure out there. Because again, if it doesn't matter what your process is, it's what you can prove. Right? In court, it's what you can prove. It doesn't matter how great your SOP is. And that's another massive oversight I see in social media right now is a lot of people, oh, just document everything. You'll be good. The fuck you will if you've never been sued before. I'm going to tell you this. It's not about how good your fucking process is. It's how good can you prove it is in court. And I just see that as a very big thing. I really do.
I'd be curious, and I know we're kind of approaching the end, but does this make a broker more valuable then in that scenario when you're talking about shippers direct to motor carriers? If you want that added layer of separation and maybe kick down liability, does a broker now become a little bit more relevant to go after and try to open up relationships with shippers directly to say, hey, this is a new development. We're buttoned up. Here's our process. Here's our process and vetting selection and insurance and everything. We can be that layer of protection for you now. Like, use us.
I
don't know. It was just a thought as you were talking. I'm like, potentially.
I've been saying that almost the entire time, Cam. I think this actually is going to make shippers work with brokers more because of that aspect of it, right? Because it's, again, the major focus to me, and I've said this 75 times since this came down, risk mitigation. How would a business remove risk from their exposure? That is like the fucking name of the game out there, man. How do you protect yourself so you can't get sued, right? Like that. And then all of these rulings, and this has already been in the back of people's minds with all these nuclear verdicts that are coming down. You would be naive to think that when we're seeing 50, 70, $100 million nuclear verdicts being awarded, that if it was that manufacturer's freight on the back of that truck, that they're not like, fuck, how do we not get involved in this? That's why I could see more of a reliance on freight brokers moving forward. And I know every carrier who hears this hates when I say that, but again, you got to look, if you don't have that ability to take on that risk, and if your insurance, because again, if contracts change, and then if I come to you as a provider, Cam, and I'm like, hey man, this shipper I'm working with, here's their requirement from an insurance standpoint, you might look at that and be like, dude, no, we can't insure you to haul this freight because you have all of this risk. Then I think it's a deep pockets game at that point. I don't know, man. I hope I'm wrong. I don't think we're there yet, but that's why I've said we got to pay attention to the next ruling, because the next ruling is going to be a lot more clarifying on a lot of people's worries. I think, unfortunately, man.
I agree. It'll be interesting to kind of watch, and all you can do is be proactive and tighten up what you've got operationally, SOP, vetting, all the insurance, all that kind of stuff. And, you can only do so much, right? Like, you can't prevent or predict or know everything that's going to happen. All you can do is just be the best version of you as a business operator and a business as you can. So, and that's the approach we're kind of taking. We're proactively pulling and reviewing insurance contracts and language, and I'm involved, on advisory boards with Great West and some other companies. And then we're involved with the state associations. And so all we can do is show up, listen, voice our opinion, try to be proactive in it, see and have our ear to the ground on what is going to happen. I mean, we don't obviously most of the time figure out what's going to happen until it actually happens, but at least we're in that conversation or trying to be there. And so proactively as a organization, that's what we're doing. So
yeah. Sonny's got a question. He says, with new companies, does shippers interest insurance help the broker and carrier?
So it'll definitely help the broker in that scenario, because obviously the shipper's interest is going to protect you, Sonny, in that. The motor carrier still, if they're negligent and at fault, the insurance companies they're still going to go try to subrogate back against that motor carrier, so it doesn't like completely absolve them of that. Now they can buy specific trip insurance if they don't have enough on top of the shipper's interest, but keep in mind shipper's interest is protecting the load. It's going to protect the customer of the freight broker, but it doesn't necessarily like provide full protections over to the motor carrier. So they still might have some responsibility to make sure that their cargo limit and stuff's adequate on that.
Perfect, man. I love it.
Covered
Cam,
the
thanks for
value
jumping
there.
on today, brother. I really appreciate it. How does anybody reach out to you to find out more about what you got going on?
LinkedIn's probably the best way, or shoot me an email, Cameron, Cameron at valleytruckinginsurance.com. You can go to our website. And yeah, I mean, I'm on social media, so try not to be as much as I can, but I do get the messages and people get a hold of me through there. So
perfect. Sounds good, man. Cam, thank you so much for your time. That's going to be it for today, ladies and
Yeah,
gentlemen. As always, if you got value in what you heard and you're not subscribed, subscribe to the show, you guys. And if you're feeling ambitious, rank it on iTunes and Spotify, because if you see value, your network's going to see it as well. I appreciate you guys. I love you guys, and we'll be talking to you soon.